Mr. A, now let's say Mr. A is the purchaser, Mr. B is the seller. Mr. A, who is the purchaser, has a duty before paying for the land, before completing the transaction, before buying that land, to verify its root of title. That is, he has to trace the land to its earliest owners or ownership. So he asks Mr. B some questions, makes findings, and goes about an entire process to be sure that Mr. B actually has the title that he wants to confer on him in exchange for value, in consideration for value. The Latin maxim that you should be familiar with if you've been watching this channel over the 5 years that we've been coming to talk about law, or if you've been following the Latin for Lawyers series, you would know that nemo dat quod non habet is a very important maxim in property transactions. It means you can't give what you don't have. Maybe much more important than Uberima Fides. Indemnity as a concept means that you will be restored to the same financial position that you were before a loss occurred. Of course, you will not be allowed to profit from an insurance policy. If you have insured your car, for instance, and there's a loss, maybe you're insured a certain brand of car, a make of car, you will be restored to your financial position before the loss, but you will not be allowed to profit from it. So the insurance is not Leo Batojo Ewa Lubuku. You know how that's a Yoruba proverb that means that in the event of a loss, what is built or what comes up is better than what was destroyed. That is not. Hi, I welcome you back to Battle of Ipola. My name is Mujola Olua, and today we want to discuss a very important judicial precedent. It's a 1971 case. We want to talk about Nettleship and Weston. So he sued Mrs. Weston actually for negligence. You know, we've talked about negligence on the channel. You already know that with negligence, you have to show that there was a duty of care owed to you as a claimant by the defendant. You have to show that the duty was breached. You have to show that there was a resulting damage, and then you claim for damages. So those 4 things. So when it came to court to ask for damages, you know, Mrs. Weston countered and said that no, violently non-fit injury. We talked about that on the channel. Please watch that video. It means that you cannot profit from an injury that you consented to. So the standard of care expected is the same to prove negligence in a case of in a car incident. The court held Mrs. Weston liable. You wonder, how can I overawe or intimidate the president, for instance? That's what the criminal code says. I mean, you look at yourself, you are a private citizen. It's even possible for you to intimidate the president. You can't even go near Aso Rock in many instances, talk less of going through all of that security to get to the president. No, you don't have to see him physically to be able to intimidate him or overawe him. If, for instance, you try to take the president out, you know, maybe to kill him, assassinate him, you know, have him gunned down, have him poisoned, anything that you can do that can make the government come to an abrupt end, not by the democratic process, can be interpreted into treason. Anything that, when I say make the government come to an end, essentially take away the life of the president or bring that government to an end, not by a lawful means or a democratic means. It can be interpreted into treason and treasonable felony. In those. Hi guys, I welcome you back to another episode of Battle of Itola. My name is Mujola Olua, and today we want to do a very practical thing. This is a labor and employment law video. As you know, I'm a labor and employment lawyer, so I have here once again another employment letter. If you remember the video that we did on one of my employment letters, where we looked through it, looked at the compliance with the Labor Act. No, what we did that time was that we looked at the clauses and we went over them, what they meant and all of that. So today I want to look at this employment letter in light of the Labor Act. So what we're going to be doing is that we're going to look at some provisions of the Labor Act and then check to see if this employment letter actually complies with it. I am not going to be disclosing some private information, but the things that can be made public are going to be made public, and you are going to enjoy it. Grab a seat and let's talk about contracts of employment in this video. Hi, welcome back to Battle of Itola. My name is Mujola Olua, and I'm super thrilled to have you here once again on the channel. Please subscribe to the channel if you haven't, and always check the description box down below to see our offerings. This video is just for me to reflect on briefly on my visit to Kirikiri the other day, and just to explain the categories of people that you find in prison. It was because I was thinking, oh, if God's going to defend them, who is he going to defend them against? So, you know, I used to be a prosecutor, so if I was to say amen to that prayer as a prosecutor, that means God is defending them against me. Usually if you go into a prison, after they've registered you outside and they let you in to the big door, the place where you would enter, that is between the prison courtyard and the outside world. That place is like the reception of the prison.
The law does not concern itself with trifles. What are you telling the court when you are using this? You are telling the court that this thing I'm being charged with, if it's a criminal matter, or this tort, this liability that is being imputed upon my person, if it's a civil matter, is so trifling, so minimal, so minute, so ignorable, if there's a word like that, that I don't see any reason why this court should adjudicate on it. I don't see why we should clog up, the justice system. I don't see why we should waste the time of the court and the time of every other person concerned by, going through this case. It is so minimal. In what instances can you use this de minimis? Let's say you are being accused of stealing a handful of groundnuts. Look at that, a handful. Stealing is stealing nonetheless. But when you look at the damage that's been done, if you have stolen a handful of groundnuts, there's a high likelihood that it has not done much damage to anyone concerned. So coming all the way to court to redress it will be trifling, in some instances. Now let's say that's groundnuts, yeah. How about if you stole a handful of gold?
We equally filed a further affidavit dated 12th of August 2025 and a reply on point of law dated and filed on the same date. My Lord, our further affidavit seeks to address paragraphs 6 and 7 of the respondent's counter affidavit in particular, and attached to the affidavit is exhibits A1 and A2. My Lord, our reply on point of law seeks to put before this court a recent Supreme Court decision which effectively ousted Madukolu and Jokotolu, which the respondents relied on in their written address. My Lord, the Supreme Court case of John and James is the current position of law on this matter. We seek to adopt our written address and our reply on point of law as our argument in this matter, and we rely on all the paragraphs of our affidavit in support and our further affidavit. We urge your Lordship to grant all our prayers and to refuse the arguments and the prayers of the respondents in their entirety. We are much obliged. Then the other party will move their counter. Now you have moved one, there are 3 lines now. 1, then 2, then
Hi,
3. My name is Mujola Oluwa and I welcome you back to Bat of Bitola. Today we want to talk about a very important topic. We want to talk about champati. Actually champati. Champati. As pronounced, that's the spelling Champerty. Champati is a phenomenon or a concept that is largely illegal in Nigeria and in most common law jurisdictions. What is champati? Let's break it down in simple terms. Let's say A and B are fighting, and then you come in as C, encouraging A or B to go to court, promising I will fund your lawsuit on the condition that when you win, you will pay me so and so portion of your judgment sum. That is champati in its basic form. Essentially, you're fomenting strife, you're fomenting litigation for gain. You are an investor investing in litigation. Hi guys, welcome back to Battle with Ola. My name is Mujola Oluwa, and on this episode we want to do a live sample of allocutors. So before us we have a case of assault and attempted murder. Hi guys, welcome back to Battle with Ola. This is another episode of allocutors live samples. This is the 3rd in that series. Hi guys, welcome back to Battle with Ola. My name is Mujola Oluwa, and if you've been following this series, this is the 4th in the live sample allocutor. Please leave comments in the comment section and share this video with someone today. I will see you in my very next video. Don't forget to subscribe. Toodles! Any person who undertakes to take part in forming a company with reference to a given project and set it going, and who takes the necessary steps to accomplish that purpose, or who with regard to a proposed or newly formed company undertakes a part in raising capital for it, is deemed a promoter of the company. As to full disclosure can be categorized in 2 ways. We've talked about duty to disclose all material facts. Those are the examples I have given. Because the fact that you're a player in the market, the fact that your blood brother is bidding for a company contract, those are statements of material facts. So you need to disclose them. So the promoter has a duty to disclose material. This is the promoter behind Battle with Ola. To-dos. Hi guys, welcome back to Battle with Ola. My name is Mujola Oluwa, and this is a brand new episode the first of a brand new series titled Waiting Lawyer They Do Serve. Trust me, the inspiration or this title itself came to me in an interrogation room. Something that some clients do not know, that some laymen do not know, is that it is not so much about what the lawyer says, but about the presence of the lawyer with you at that law enforcement agency. It prevents a lot of things. There are questions they will not be able to ask you when your lawyer is present, which they would have asked you if your lawyer were absent. Also, if it turns out that the agency wants to detain them unlawfully or needlessly, your duty as a lawyer is to prevent it. Don't panic. Don't say waiting lawyer they do serve. Get yourself a lawyer. Most important characteristic of a mountain is that it is immovable or shakable. Look at the words that were used. It said, which cannot be moved. It is like the rock of Gibraltar or Mount Zion, which cannot be moved. Mount Zion in particular, when you look at Psalm 125, for instance, I used to live with a family where for about 1 whole year, every night we recited Psalm 125. So I know it like the back of my hands. The first verse says, those who put their trust in God are like Mount Zion, which cannot be moved. That's the first line. We can confirm it. Those, in fact, this is the way we should read it. They that put their trust upon the Lord are like Mount Zion, which cannot be removed. As the mountains surround Jerusalem, so the Lord is round about his people from this time forth and forevermore, and so on and so forth. So that allusion is very correct and very apt, to have been used by the justices of the Supreme Court to say that the time fixed for election petition cannot be moved. Just like if there's a shortage of manpower, it could happen. It could happen in case of conflict of interest, in case of expertise or geographical convenience. So that is what farming out means. I hope you understand. Let's continue the conversation in the comment section, and I will see you in my very next video. Please subscribe and bring a friend along to Battle with Ola. My name is Mujola Olua. Toodles. Hi guys, welcome back to Battle with Ola. This is Mujola Olua, and I'm super thrilled to be here once again. Thank you so much for the show of love, and thank you so much for all the pleasant and all the positive feedback that we've got so far on the channel. It's been amazing. It's been a blast. Thank you so much. I'm personally so happy, so grateful to God that I get to be a part of so many lawyers and law students and laymen's law, legal and law practice journeys, and it's really fulfilling and thrilling. Thank you. Today I want to talk about fiat. F-I-A-T. When you're a servant working in a government establishment, a lot of things will be happening to you. And there'll be days where you just be shouting wow like an ambulance. This random reminiscence is supposed to be about something else, which I'm going to get to, but as I was preparing, I just remembered the time that I went to court and I came back and my desk, my chair, was outside in the corridor of our department. In fact, it was not just outside in the corridor. Water had poured for some reason. My constitution, my one and only hard copy constitution that I had since probably 2012 or 2013. That was the day water poured on it. I think that was the day water poured on it, if I'm remembering correctly. And the water stains are still there till today. Why were my table and chair outside? They were renovating my office for a political appointee. But that's not where we're going today. Hi, I want to tell you about my books. I wrote some books that I want you to buy. The hard copy is coming out in 2025. The hard copies, for some of them, coming out in 2025. But the e-copy is still available. They are published as far back as 2023. There's a collection of 10 short stories called Inchoate. Please buy it in the link in the description box. Also, there's my 3-year mediation journey reduced into writing called On Your Marks, Get Set, Medit. It's also in the description box, the link to buy it. There are some other books. There's C'est la vie, which is a collection of poems that I wrote. Please buy it. The link is in the description box. I love to write and I love to share my writing with the world. I'm hoping that you are edified when reading or by reading, and I hope that you get value for your money. I will see you in my very next video. Thank you so much for buying my books.
I welcome you back to Battle with Ola. My name is Mujola Olua, and today we want to continue the series on defenses in law. I want to talk about the defense of accidents. From what the word ordinarily means, accidents means an unexpected thing that has happened. Before we had even gone to the police station, we had contacted the lawyer on the other side. We tried to schedule a meeting, and there was a tough tussle going on. Eventually we went to the lawyer's office to meet with her, but she insisted that her client wanted the guy to buy the car, the big daddy, and then pay for the damages to the other cars before anything could be done, An event that occurs by accident is one that is too remote and is an indirect consequence of an unlawful act or omission carried out by the defendant. Essentially, a reasonable person, a reasonable man in the shoes of the defendant would not have foreseen or expected that result or event or occurrence to happen.
The document has no name. It's purportedly a document showing private information of the company to be tendered by an officer of the company, but it has no name of the company on it, has no logo of the company on it, it's not signed by anybody, not even by the witness that is supposed to tender it. It's basically a worthless document if you look at the decisions of court on unsigned documents, undated, unsigned, and they pleaded it in their evidence, in their statement on oath. So when we get to that bridge, we're going to cross. Who is a nominal complainant? A nominal complainant is the person that makes a report of criminal activity to the police or law enforcement. If someone has been robbed and then they go to a police station to file a report and to put down their own statement, they are referred to as the nominal complainant. The matter will eventually go to court and they may be called as witness, prosecution witness. They are the nominal complainant because they are the one who complained that something has happened.
So that's section 28 of the criminal code, and as you can see, it's talking about two different things, or two things, that are all tied up to this defense of insanity. We've cleared up the first part where we've talked about the two legs on which the defense stands. Now, the second part caters to insane delusion. Delulu is not the Sululu. Now, what do we mean by insane delusion? It is an irrational and persistent belief in an imaginary state of facts, in an imaginary state of things. Someone just imagines or just insanely believes that something is happening when it is not. For instance, a woman believes that a baby, a doll, a plastic doll is an actual baby, is her baby, and she believes and caters to this baby as if it were a real child. Now, she persistently and insanely believes that it is an actual baby. But to you, who is of sound mind and normal mind, you know that it is a plastic doll. We had a case, we prosecuted a matter back in 2020. We prosecuted it, we finished it in 2022. We got the judgment in 2022. And it was a murder case. And the defendant had claimed in his statement to the police that he heard a voice that told him to go into the farm and kill the man that he murdered.
Hi guys, I welcome you to a brand new episode of Battles with Ola. My name is Mujola Oluwa. That's where the Ola is from. Please, if you want to shorten it, Ola suffices. So, in this scenario, Mr. A, or let me give him a finding, Mr. Adaramola has resigned from his job. So in this simulation, Mr. Adaramola, a Gen Z, has resigned from his tech bro job because he's being owed a 4-month salary, and he's got another job, or maybe not, but he's been asking, even after resigning, he's been asked, he followed the due process, he resigned, gave them notice period, and then he was asking for his money and they have not given it to him. He has tried all means of amicable settlement, wrote them a letter of demand, went to a state mediation house, to see if it can be settled. His employers did not show up, or let's say his employer did not comply, and then now he has taken legal action. So today is the trial date, the case has been mentioned. Today's trial date, the case has been mentioned, and now Mr. Daramola is the sole witness in this areas of salary matter. Witness, tell this honorable court your name, that's who, what you do for a living, that's what, and where you live. Or witness, tell this honorable court your name, where you live, and what you do for a living. Handwriting or finger impressions, they are experts. I've witnessed a court proceeding where the court had invited an handwriting expert to look at the handwriting of someone that had executed an agreement to confirm if that is their handwriting when placed beside other documents purported to have been made or executed by them. So that kind of person, that is their line of trade, that is their profession. They are versed, they are skilled in determining the handwriting of persons, connecting the writings to the hand that wrote it. So that person is an expert. Customary law too. People can become, especially when we go down in the act, you will see that, for instance, traditional rulers,
Generally we call them the custodian of culture and tradition. So if we have a baale or a king in a society now, he can be called upon as an expert on the customs and traditions of that locality. And for that purpose, he would be or she would be an expert, properly so called. 69. I'll just run through everything now. Where there is a question as to foreign law, the opinion of experts who in their profession are acquainted with such law are admissible evidence of it, though such experts may produce to the court books which they declare to be works of authority. On the foreign law in question, which books the court, having received all necessary explanation from the expert, may construe for itself. For instance, Professor Itse Sagi, is a constitutional law expert in Nigeria. Is known for that area of law. He can be called upon in court and his opinion given on a certain aspect of constitutional law, maybe an interpretation of an aspect of the constitution. He can be called upon, and in that regard, he will be an expert and his opinion will be admissible. His opinion, not even facts, his opinion, because he's an expert. For instance, Professor Damilola Olawi, SAN, is an expert in environmental and energy law.